When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.
Every citizen has a right and every citizen has an obligation.
That a plea of ultra-virus acquit or convict is very different from the plea of pardon.
Trespass is that act that interferes with the peaceful.
No matter how minute this,
right? No matter how minute.
Who comes to equity must come with clean hands. Hello out there, you are welcome to another fresh episode of the program Justify Nigeria on ACNN television, reaching you from Abuja. On today's episode, our subject of discussion will be on the legal concept of trial. My name is Anoze Chinomso, your anchor. A trial is a legal process that is used to determine on whether or not an accused person is guilty of the crime he is charged with. In other words, a trial exists in order to ascertain the level of innocence or otherwise of the accused person. We must, however, underscore the fact that there are certain legal principles and steps to follow in order to ascertain a fair trial. The trial of Mazi Nnamdi Kanu, the leader of the indigenous people of Biafra IPOB, went viral. Legal experts and international communities were very dissatisfied with the manner in which the trial is being conducted. What then is trial in its entirety? What are the legal rudiments that will justify a fair trial? What do you think that may be the cause why the trial of Nnamdi Kanu is being conducted in the manner that the federal government is doing? Joining me now in the studio to provide and explain the legal dynamics of all this is Barrister Festus Ntang. He is an experienced Abuja legal practitioner, associate member, Institute of Chartered Mediators and Arbitrators, associate member, Institute of Professional Managers and Administrators of Nigeria. He's also a partner at Chizo Consultant, event comparer and communication strategist, and also a member of Unity Bar here in Abuja. You're welcome to the program, sir.
Thank you so much.
Thank you very much. We hear about trial. Whether you're a lawyer, you're not a lawyer, just like our viewers, they will hear about trial. But you agree with me that there are some people who they don't know what trial is all about. Can you just tell us, let's start from there, what trial is all about?
I always try to be as simple as possible.
Very important.
Trial is simply a process to determine if someone is guilty or not guilty. That is in criminal matters, or culpable or not culpable. Or just trial is basically to just prove. Okay. Just prove what is.
You don't just see somebody and say he's guilty. No, you have to take him to that process of trial.
It's a process. It's true. Okay. So it's a process. You're bringing your evidences, your arguments in support or not. So it's a full process to determine if an individual is guilty of an offense
or not. That's just what it is. Thank you very much. But now, you also agree with me that not all trial are fair. Oftentimes people say how this trial was conducted is not fair. Can you tell us what constitutes or how we can determine a fair trial?
Okay, yes. To determine fair trial, we have basic principles of law that we rely on, that the courts rely on. You know, the Temple of Justice rely on these principles. First of all is audi autorem patem.
You know, you promised me before now. You are going to break them down.
Yes,
all right.
We're trying our best. I still like Latin.
But that's the legal maxim, am I correct?
It's a legal maxim.
Okay.
Yes.
It says
audi autorem patem. It just simply means hear from the other side.
Okay.
So, as part of the rudiments of a fair trial is you must hear from the other side. You shouldn't hear only one side of the story. You should hear the other side of the story. So that is the first principle rudiment for a fair trial. Okay. So it's unfair if you're hearing only one side. Oh, he slapped me, he's guilty. That's unfair. That's not fair trial. Okay. Now the second rudiment is you cannot be a judge in your own case.
But I think there's a legal maxim people use. You can say it and also try. I like that. How is it? Because even our viewers, we like to all know what is that one.
Nemo judex in causa sua.
Okay. Oh, that is what you just translated.
Yes, you cannot be a judge in your own case.
Okay.
In other words, it simply means, as the popular parlance, judge, jury, executioner. We have that that construct. It just means that it's my case. I am a party in the matter. I cannot be the one to judge the matter. I cannot be the one to determine the guilt of the opposing party because I am a party in this matter. So the idea of this principle is to elaborate and to enhance the principle of neutrality. So you're bringing in someone who is neutral to determine the guilt or otherwise of this person.
Okay.
Yes. Okay. That is what that
means.
Or
the utterance pattern.
Or the utterance pattern.
You cannot
means.
Yes. Now, if then it's basically you gave us two principles.
Yes. Two basic
principles. Other things can be embedded.
Yes.
But now you agree with me. Oftentimes there's what people call ex parte motion, by which oftentimes some order can be granted in the absence of the person. That is, you can dispense with the physical presence of the other party. Yes. In that case, the principle of audio utterance pattern, will you not say that it has been violated? Explain to us.
Yes, I'll explain this.
You understand what my question?
The basic reason or need for an ex parte order usually is to protect the subject matter of litigation.
That's what you call rest now.
Yes, the rest. Thank you. The rest. That is the subject matter of litigation. So the subject matter, for example, may be a car. And I don't want your presence in court now, but I just want that car to be preserved. So I approach the court via an ex parte order. It just means without notice. I don't have to tell you, but I want the court to probably bring the car and put it in their custody.
Okay, so that they will not sell it out or whatever.
Yeah, so that we don't lose
the subject matter. Okay, it's not necessarily
substantive suit.
Okay,
there's a matter going on. We just want to protect the rest. We don't want it to be tampered with, so that we know once I get judgments and the court decides the car is mine, I should be able to benefit. I should be able to reap the rewards of my labor. So that's why we need that to be protected. Because now, once there's an ex parte order, there's always a substantive suit.
Okay. The matter has not been determined on its merit.
It has not been determined.
Okay, so you cannot say that order pattern had been violated.
No, it has not been violated.
Okay, that's what you want to clarify. Okay, there's substantive suit, but just to preserve the rest.
Yes, which is the subject matter.
Thank you very much. Now we are looking at a scenario here. Now, if, for example, my father is a judge, and I'm involved in a case, on the second principle you gave of nemo judex in causa sua, does it mean that my father cannot sit as a judge to adjudicate my matter? Is it what do you mean by that?
Okay, so
because we want to look at the scenario by which our viewers will understand.
We can take it on two
Okay, please go ahead.
I take it first of all morally, and this because it may affect, subject matter. It may affect. It may be affected in terms of. I'm trying to get the exact words to use here. Conflict of interest.
Okay.
Conflict of interest. This is your father, for example, and he's sitting on your matter, and he's probably in the end going to determine your guilt or not. And so morally speaking, that empathy will come in and all of those things. So definitely conflict of interest would arise. So morally speaking, yes, it's not ideal that your father will be the judge to sit on your matter. On the flip side, on the legal side, there is no express provision of law that says that he cannot sit on your matter. My position is due to the fact that, yes, he's a judge in his right standing. And if it is possible, which I hardly think so, for him to actually sit and show us that his decisions will not be biased in any way,
despite the biological son.
Despite the fact that you are his son, his decisions will not be biased. The trial will proceed without issues of, conflict of interest and all of those things. Why not?
Okay, but just like you said, you doubt.
I doubt
the possibility will not be there.
It's rare. You understand?
The empathy will always be there.
If it is possible, why not? He's a judge in his rights. And yes, he can. The matter came before him.
Okay.
He was not there when it happened. All he knows is there's a matter before me. I have to dispense justice. So at this point, like we mentioned, conflict of interest. If he cannot dispense justice, he removes himself from the matter. Yes.
So at any particular point in time, any trial is not being, that is the presence of these two things are not being seen, you can't determine that is a fair trial. Those things, must be present.
There are other principles, or there are other factors.
Okay.
Yes, and you can look at them from the Constitution as enshrined in Chapter 4, and you see issues of, you have to give the defendant ample time to prepare his defense. He has to be informed of why he's in court. Okay. So you don't just drag him and say this is what is going on. And you bring him to
must
court.
Inform him.
You must inform.
It is right.
Yes, it is right.
You will take it off from there. We'll come back for break. It's becoming interesting. Please, viewers, do join us again. Hi, you are welcome to the speaker on ACNN television, reaching from Abuja. The speaker is a platform by which we treat some topical issues happening in the community. My name is Anoze Chinomso. On today's segment, we are going to be looking at the concerned Nigeria or an unconcerned Nigeria. It is a common knowledge that when one is concerned about something, he becomes interested and involved in that thing in order to contribute in making it better. But when the word unconcerned is involved in anything, there is unproductivity, lackadaisical attitude towards things, and unwarranted stagnation. With the kind of inconceivable and unfathomable things happening in Nigeria, I am moved to ask on whether we are living in a concerned Nigeria or in an unconcerned Nigeria. In a situation where 2 military generals and at least 72 persons were killed few weeks ago is a perfect example of an unconcerned Nigeria. In a situation where 2 out of 66 worshippers adopted from Emmanuel Baptist Church, Kakao Daji in Chikunu local government area of Kaduna State were shot dead on Sunday is a clearer example of an unconcerned Nigeria. Where retired Air Vice Marshal Muhammad Miseka was gunned down by unknown gunmen at his residence in Ragishi, a Gabi local government area of Kaduna State, is a perfect example of another unconcerned Nigeria. Armed bandits reportedly killing 6 persons and adopting many others during an attack in Rigia village in Gazo local government area of Zamfara State, and also killing 7 mobile police officers in a separate incident makes it clear that we are living in an unconcerned Nigeria. At least 6 people have been killed in an attack in Gwazo community in Matazu local government area. At least 5 people have been killed in Angara in Isialambano local government area of Imo State when gunmen attacked the community on Tuesday night. At least 15 people, including 3 housewives, have been killed in Binari and Jab villages in Kasim Lamido local government area of Taraba State. Brigadier General Dazama Zekis and the other soldiers were killed in a fierce encounter with Islamic State's West African province, ISWAP, terrorists in Borno State. Gunmen shot dead at least 4 mourners during a funeral ceremony in the rural village at Mbayatu Mbata Council Ward of Logo local government area of Benue State. In all these tragic reports and stories, what has Nigerian government done? Absolutely nothing. Why? Because they are very much unconcerned. When last did you hear that peace and tranquility have returned to the state in the north? Have you ever heard in Nigeria of today that there is maximum security of lives and properties in all the regions of Nigeria? I did not hear. Why all this? Because our political leaders who occupy these positions of leadership are not only complacent and stagnated, but also unconcerned. How can it be that the perpetrators who raided the house of Honorable Justice Mary Odele have not been apprehended up till now, let alone charging them to court? How can it be that the news we read in the national dailies and the ones we listen from radio and watch in television are all tragedies? How can it be that the Minister of Information, Lai Mohammed, has described the NSAS report of the Lagos State panel as fake and tells by moonlight? How can it be that a former FCT director on protocol and Zamfara governorship aspirant in the person of Alhaji Shagi Hamid was killed by unknown gunmen along Abuja-Kaduna Express route? How can it be that nothing seems to excite one in Nigeria anymore? How can it be that corpses of lifeless Nigerians have become a palatable meal for the vultures? How can it be that our mortuaries and cemeteries have no more space because of the high toll of dead bodies on a daily basis in Nigeria? How can it be that even some electorates are supporting this evil going on in Nigeria because they are benefiting from the evil in one way or the other? How can it be that every 4 years we go to the polls to elect hyenas and cheetahs in place of leaders to take care of goats and sheep, and when they are consumed, we wonder why? How can it be that our government appoints goats to take care of yams, and when they are eaten, we wonder why? It then means that there is a sense in which we, the masses and electorates, are co-authors of our own misfortune. We must stop this if we really want to move as a nation. In order to justify Nigeria, I therefore speak. Until we all begin to say something and do something when we see something, endeavor to ensure that you play your own part and I play my own part, and the government on their own part cease to be comfortable in their comfort zone and begin to squarely face the problems of this country. Get more concerned on the issue of Nigeria in order to bring a lasting solution to the problems of Nigeria. We shall continue to live in an unconcerned Nigeria instead of a concerned Nigeria. My name is Arnold Chinomso. I just want to speak. Glad to know that you are still there, and we are still right here in the studio with Barrister Festus and Tom. Yes, Counsel, before we went on break, you are trying to educate our viewers that once an accused person is brought to court, you don't just, dispense him, like you must tell him the reason.
Yes,
is it a constitutional right?
Yes, it is
How
his
do you
right
mean?
to be,
Tell us.
it is his right to be informed of why he is in court. Usually the process of trial starts from arrest.
Oh, it's not just coming to court.
It's not just coming, it starts from the
Okay,
arrest.
that's what people call arraignment or something.
It starts from when he's arrested. How was he arrested? There are provisions for this. He has to be informed in a language he understands. He has to understand, oh, this is the offense. Then he's given, then he's taken to court, the provision that, oh, within a reasonable time he should be charged to court. If not, please leave him to move, leave him alone before you get to court, and then he's arraigned. He's before the court. He takes his plea before the court, and yes, you're all of these principles start playing.
Okay.
So that's why I told you
it's a process.
It's a complete process. It's a complete process from how his confessional statement was taken, if confessional statement was taken, to the tendering of the. It's a complete process, and that is why it's very it's fragile. To such an extent that if it is shaken in some way, if one of these principles has not been properly adhered to, then there may be a problem.
Oh, it can be also a tool for that's a real objection?
Yes.
Even on appeal?
Yes, even on appeal. Even on appeal.
That's serious.
Even on appeal.
Thank you very much, sir. And now, Council, we have over the weeks hearing about this IPOB leader.
Yes.
And as much as we're not here to criticize the government, we're looking on points of law to educate our viewers. Now, the trial, of course, of Nnamdi Kanu, international community and some legal experts, of course, opinions are divided that the manner by which his trial is being conducted is not right. As a lawyer, experienced lawyer at that, what is your legal comment on the trial of Nnamdi Kanu?
Okay, I'd have to be very careful.
Exactly.
My training has imbibed, the matter is in court, let the court decide. The matter.
However, but we're looking at the process of trial, which is a subject, which is the rest now.
Yes,
the trial, which is the rest of this episode of the program. Yes. All right,
we're looking at the process of trial, and for me personally,
first of all, you look at the two pillars you have told us, whether and all that rudiments. Please go ahead. Yes, whether they are before.
One of the rights of an accused person is that he has rights to counsel. And I think for me personally, I think every other legal practitioner out there, I don't think it is right, I don't think it is just, I don't think it is fair for the authorities to deny Nnamdi Kanu his right to counsel. He has rights to choose.
Is that right, a constitutional right?
Yes, it is a constitutional right. He has rights to choose his counsel. And I can understand that, yes, the matter may be sensitive, security matters, national security. Yes, our practice allows the courts to set up special courts, to deal with certain sensitive matters. So you may not have, the conventional, everybody coming kind of situations. Yes, I can understand that since this is matter of national security, we may not want to expose everybody to it, so we want to be very conscious about that. However, even in those situations, the accused person still has his right to counsel. So for me, it is not right that Nnamdi Kanu is denied access to his counsel.
It's not legally
it's
right.
Not legally, exactly. Yes, it's not legal. It's not fair for him to be denied access to his counsel. For whatever reason, he has rights to his counsel. So
at any time,
yes, he has rights to his counsel. Even in detention, he has rights to his counsel. It tells you, I want to speak to my lawyer. Please find a way, arrange for his lawyer. Yes, you may decide to put it in a secure location, tell the lawyer, or arrange. But the important thing is he has rights to his counsel. So, what happened on the last adjourned date in court as to the DSS locking the place and denying his lawyers access into the courtroom was totally just unfair. It was just unfair.
And it's unconstitutional as well.
It's not constitutional. It's not constitutional.
Based on point of law is what Barrister Nchong Festu is talking about, that on the constitutional provision of determining a fair trial, the issue of trying to deny an accused person, not necessarily Nnamdi Kanu in this case, is not just only unfair, but unconstitutional. Now, Counsel, thank you for that insight. If an accused person now discovered that his trial was not fair, for example,
yes,
are there any legal option that is available to him to seek a redress?
Yes, at every point you can always appeal.
Okay.
You can always appeal. The idea is once a court has delivered its final judgment, it becomes functus officio. It just means that the matter is out of his hands.
Okay, that's the meaning of that legal maxim. Now, you lawyers people are very good with it. Okay, functus officio simply means
it cannot function. On this matter, again, he's done. He has given his final judgment.
Okay. Just like in a police after finished service. Once he has finished that service, he can't just go back to that service. It should be another one. Yes. So once a judge now finished the matter,
he's done. So the remedies or the results that an unsatisfied
accused person on a trial is to appeal. So it then means that if he can sustain his claim in appeal, whatever the lower court must have done, he can also vitiate it over there.
Yes, it can be quashed on appeal, and once it is quashed on appeal, any decision reached at the lower court goes to no issue.
Oh.
Yes, the decision can be reversed. It goes to no issue.
In a situation he goes on appeal, for example, in court of appeal, and he's still yet dissatisfied, can also appeal to Supreme Court.
Supreme Court, yes.
Okay, that's the process now,
that's the hierarchy.
Oh,
but
okay.
After the Supreme Court, well,
somebody will say it's God.
It's God, exactly. It's God,
so you just accept your fate.
You accept your fate at that point.
Oh, we just have a few minutes to end this program now. Counsel, please, what is your general advice to our viewers in the issue? Because you can see oftentimes people will be shouting how this trial was conducted to my cousin and all that is bad and all. What is your general advice on points of view to our viewers in case if they are confronted with this kind of situation?
Usually what I would advise is get a lawyer.
Which you are one of them?
Yes.
You look at them and
yes. You get a lawyer. The reason is because they know how to approach these matters. They know how to tackle these matters. I've seen a lot of times where clients feel, oh, we know how to do all of these things, and I feel, okay, no, I don't have an issue, go on. But when they usually end up having issues, they come back and tell you, this is what you've done, this is what you've done, and then you find that you are now trying to remedy situations which
couldn't have occurred in the first instance.
So when you find issues like this, usually I think best bet, just consult a lawyer. Let him, particularly if you're
that's what he's trained for.
Yes.
So he knows the dynamics, what
he knows what it is. He knows what it is. That is it. And just get a lawyer, and also try and stay out of trouble. That's another.
That's another thing.
Just an aside. I have friends who say, I can look for trouble now, and I say, please don't look for trouble.
Okay, because they have you as a lawyer. They say, yes, that's on the lighter.
Don't look for trouble if you don't have money. Yes, that's
on the lighter mood anyway. So basically, your advice to our viewers: let them get a lawyer once they're constructing. You have issues, or you have people that have such issues.
Yes.
The issue of self-help does not arise. The issue of trying to handle it yourself does not, because you don't know the dynamics and the legal integrity that are connected to those things. Want to appreciate you, sir, for coming.
Always
Thank you very much. And out of your busy schedule, when next we invite you, please try to oblige us. Thank you very much. The legal trial is a wonderful and legitimate process in the administration of criminal justice in Nigeria, and thus its relevance and importance cannot be dispensed with. It is, however, advised that when trying an accused, the trial must be conducted in a manner that is justiciable, equitable, and justifiable. A situation where a trial of a person from a particular part of Nigeria seems to be different from another person who hails from another part of the country is not only bad, but incurably bad. The government of Nigeria must endeavor to ensure that all citizens of this nation are treated fairly in all things. Never you forget that Nigeria is the only country that we have, and there is no other country we can call our own except Nigeria. It is therefore advised that both the leaders and the led must put hands on deck in order to ensure that the better Nigeria we all are dreaming of will manifest into reality someday. This is where we draw the curtain on today's episode of Justify Nigeria. Join us same time, same station on another fresh episode of the program. Until then, this is Anoze Chinomso. Wishing you the very best, and bye for now.